all parties afterwards, just for good order's sake. So recording is now activated. Sorry, Farah, you were saying you represent an insurance company.
The insurance company, yeah.
Okay, so on the basis of that, does, forgive the Americanism here, but does client-attorney privilege apply if we know certain things or don't know certain things that may be prudent to the case?
Oh, absolutely. So we'd still need all the information you've got, because through agency, you are still obviously named on the proceedings. So for the purposes of the litigation, we're representing yourselves, but we are taking instructions from the insurance company, if that makes sense.
Okay, that's fine. That's fine. I don't think I've got any further questions on that point. Julie, I'm not sure if you've got any further questions on that point.
No.
Okay. In that case, then, yeah, if you would be so kind as to give us an update as to where we are up to with the case, the proceedings so far, and any upcoming actions that require our attention in the next few weeks, that would be good. And I think the logical way forward. And then depending on the outcome of that, we probably need to have a discussion with you about our understanding of things.
Absolutely fine, yeah. So where we're at in terms of the litigation, so we've got a pre-trial review on the 10th, so that's on Monday. And we've got counsel instructed to attend that. Essentially, because we're not ready for trial, I don't know how much you're aware of the expert evidence, but we've requested some we've asked some questions of the expert, and the expert's not come back to us as of yet. He provided a brief sort of interim update saying there's certain questions he's not willing to answer. So we've gone back and challenged that. That's in relation to all three parties, because he's refused to answer sort of all of them. So we need further directions from the court on that point. So we've raised that with the expert. As I say, we have challenged that, and he's in the process of responding to those questions. Now, once we've got the answers to those questions, we intend to mediate. And I think I discussed that with you previously, Stuart, that we are looking to go to mediation on this matter. We are not obviously in a position to go to mediation until we have, details of the losses, and because otherwise we've got no basis to negotiate on. So based off that, as I say, we need the responses from the expert in relation to the questions that we've asked. Once we've got the responses to those questions, we then need a schedule of loss from the claimant, so just to sort of clarify exactly what is being claimed. Once we've got the schedule of loss, we'll then be in a position to actually put some figures down and to negotiate on the matter.
Okay, so just a couple of quick questions, if I may. The mediation process, if I recall correctly, is the prescribed course of action so that the insurance company is satisfied and we've explored that as a possible outcome and option. Is that correct?
That's right, yeah.
Right, and there's no way of bypassing that. We've got to simply do that process. Otherwise, the insurance will simply not cover the ongoing proceedings or outcome.
What do you mean by bypass, sorry?
Well, what I meant is if it was decided that we wanted to go straight to a judgment stage through the courts, would the insurance company support that, or does it have to absolutely go through a mediation process?
When you say judgment, what do you mean by judgment? Because we're the defendants on this matter.
I know we're the defendants on this matter, but what I'm saying is looking at this from the point of view of what's best for the overall leaseholders in the building and putting an end to this as quick as possible, we're just looking at different options about what's likely to happen and how we can solve things as quick as possible going forward. But if for whatever reason mediation was decided not to be an option, would that then invalidate the insurance continuing to support and cover the outcome?
Well, the best possible outcome in this situation is the mediation, because we are obviously obliged to follow the court timetable. So in terms of a judgment in that respect, we wouldn't actually we wouldn't actually be able to get a judgment until trial. So if that happened, we'd have to go through the sort of formal procedure in terms of witness evidence and then obviously prepare for trial and then have the outcome at trial. So that would be a lot longer in terms of the process and procedurally than if we were to try and mediate now. And as I say, once we've got the figures to be able to negotiate, because at the moment we just don't have any figures. We've got sort of brief figures in terms of well, partial figures, I should say, sorry, because the expert's given some repair costs, but not all the repair costs. So once we're in a
Okay.
position, once we have, sort of all the repair costs or, well, as much as the expert can provide, we can then begin negotiations, you see.
Okay. And the expert appointed witness, if I'm not mistaken, this is a witness, it's essentially court appointed, but signed off by the various parties to the case, ourselves, the defendant and the claimant. They all agreed on a particular individual to act as an expert witness. Is that correct?
Yes, yes. So there was two experts initially that were in the mix, if you like, and I think ultimately, I mean, either or was fine by us. I think ultimately the court did appoint the expert because I think there was some issues with availability and whatnot. So eventually the court did decide to go with Ian Holdsworth, I believe it is. So yeah, it is a jointly instructed expert.
Okay, so and presumably a verification of all associated costs. And I realise that there'll probably be other costs. I'd imagine the claimant will have loss of incomes and various other things that the expert court witness can't attribute. But most of the bulk of the missing cost information will come from the expert witness in terms of actual physical repairs to the apartment and building. Yes.
Yes, and then anything else the claimant wants to include will be in a schedule of loss.
Yeah. Okay. Understood. Okay. Okay. That answers that. So please continue with where you were up to before. Sorry, I just wanted to ask those questions very quickly.
No, absolutely fine. I mean, that's in a nutshell where we're at. So unless you've got any more questions, I'm happy to answer obviously any questions you have.
Yeah, well, okay. With what's coming up next week. I mean, what's required from us as the new board of directors on that? Are we required to sign anything? Are we required to give or validate any statements that may have been put forward previously?
No, so at the moment, there's no input required from yourselves. It's literally just a hearing to decide next steps, essentially. So the directions the judge will provide at the hearing. So the judge will then tell us how to proceed in terms of next steps, whether he will compel the expert to respond to those questions that we've asked. The judge will decide that. And then also, in terms of witness evidence, schedule of loss, what dates those are due. And then once we've got those dates, as I say, we can work accordingly and take it from there, really. Okay.
Now, this is where it gets a little bit sensitive and controversial. If I may ask, what previous has any previous statements or anything been signed by the previous board of directors, or what is the premise for us not admitting liability in this case?
No, there's been no statement signed. There's been list of documents, under sort of the usual disclosure process. That's other than that, there's been no witness evidence or anything of the sort that's been signed. So no. In terms of admitting liability, nothing's been admitted as of yet. We have the claim is defended essentially. So
I think to be honest, that's our question, because we have reason to believe that there is liability here on our side, and we don't understand why the claim is actually being refuted.
Well, quite honestly, we're acting in the best interest of the insurer client. So we could settle, as I say, and that's the intention when we proceed to mediation. But we would settle on a without prejudice basis. There's no reason to admit liability in this case as of yet.
I think I would agree, based on what the insurance company's probably been provided. There is no reason to admit liability, but the sad reality is that we are very much aware through a number of different avenues, including a number of data leaks from the previous board of directors, that there very much is a liability here. There's evidence of contractor negligence. And they, my understanding from what I was told in a very brief update from the previous board and from Watson's Property Management in this case, although the information we've been given in general as a group of leaseholders prior to becoming on the board, is that it's an ongoing legal case, but Basically there's no leaks in the building, there's never been a leak in the building, and that's our defense. Well, this for us doesn't make any sense, because how can you say there's no leaks in the building when it originates from a known design defect in the building and subsequent mishandling of contractor managements and repair jobs? None of this case and the fact we're actually defending it really makes much sense to us. I do understand from the point of view of the insurance company, they've got to go through the process, and obviously they don't want to admit liability because that's how insurance companies work. But the reality is that there is a liability here. The liability does lie with Watson's Property Management, and to a lesser degree, possibly the former board of directors. And we've got a defendant who's been severely harmed and prejudiced because of this ongoing case that there's no need for. And that's our issue with this. And this is why what we wanted to really speak to you about, because we're very concerned about it. And we just need to find out the quickest, most efficient way of ending this as possible that does not in any way put an innocent party in all good conscience. I'm afraid I couldn't support, regardless of an insurance company wanting to limit their liability, that puts an innocent party in a prejudicial position she would have been in had the case not occurred.
I mean, there's various nuances to what you've just said. The legal liability side of things. We have obviously made a contribution claim against the first defendant as well. So we're simply not in a position to accept liability on this matter. However, as I say, we are prepared to enter mediation because we do accept that there are risks in the matter. But in terms of outright admitting liability, I'm afraid we're not in a position to do that. I appreciate what you're saying, of course, but we are compelled by the court timetable. So we simply cannot just put an end to the matter. Here's everything that you've claimed, without actually testing all that evidence. And once we've seen a schedule of loss, as I say, that's when we can actually sort of scrutinize that and say, yes, this is recoverable or this is not recoverable. But until we've got figures in a formal schedule of loss, we're not in a position to do that. In terms of your question about, trying to finalize matters in the most commercial possible way and as fast as possible, really. I mean, yeah, we agree with that, because from a cost perspective, the insurer client doesn't want to pay any more in costs than they have to. So if we weren't obliged by the court timetable, then we wouldn't be in this position. But obviously we are compelled to follow the litigation timetable, and that's what we've been doing. So we are trying to resolve the matter as soon as we can, really.
Mm-hmm. But again, I think it's not just about the achieving a resolution in the most commercial and time frame expedient matter as possible. It's about actually not, as I said before, it's very important for me and everyone else that, and I realise that my mind is saying this, but it's very important that the claimant isn't prejudiced unduly. So that for us is an important issue. And our other concern is that we do not want, as a new board, to be basically signing off or approving in any way statements and submissions given by the previous board that we know are basically not correct. I think we're in danger here of potentially being backed into a corner and inadvertently committing, what's the term I'm looking for? Perjury.
I mean, I disagree with that. There's been nothing that you've submitted, or signed to suggest otherwise. So, and as I say, we haven't got any witness statements or anything signed by the previous directors, other than sort of a defence and a disclosure list to suggest otherwise. So in terms of procedurally, we do really have to follow the court timetable and obviously try and wrap matters up as fast as we can that way.
Okay. What's your expectation for resolving this following the court timetable? Subject to all parties playing ball and agreeing and getting on nicely and agreeing a final figure. What's an idealistic expectation for a time frame?
I couldn't say until I've got all the information, so it's pretty much impossible for me to say right now.
Right. Okay. No, the reason I'm asking that question again is partly because obviously the issue needs to be addressed on behalf of the claimant anyway, because it's simply an unreasonable position she's been put in. But separate to that, this case has ongoing implications for the repair of the rest of the building. So we've now got many leaseholders suffering because we simply can't progress anything because of this ongoing claim.
Yeah, unfortunately, as I say, I can't answer that because until the deadlines are in place and everybody has complied with those, we're just not simply in a position to be able to do that.
Okay. So I guess the next information we'll get will be around about the 10th or 11th after the next event.
Yeah, I will let you know the outcome of the hearing. Can I just clarify, please, that none of this information goes back to the claimant?
Yes, none of this information is going back to the claimant at all. Don't worry. Listen, please be assured, although we are aware of certain things that have gone on in the background regarding this case, obviously we're all aware of the legal issues here, and that we simply cannot discuss this with the claimant in any way. We're very much aware of that, so you don't need to worry there on any front.
Okay, no, thank you for that. So
I mean, to be
obviously,
honest, if there was any doubt of that, of the kind of questions I've been asking you, I would have been asking them if we were on speaking terms with them. But I can honestly assure you, there's been no contact with myself or the board of directors as a whole with the claimant on this matter.
no, that's absolutely fine. Thank you. Okie dokie. I mean, from my side, is there anything else you need from me?
No, I think that's everything. Julie, have you got any other questions or anything?
No.
Okay.
Just
What
I
is it?
suppose the only one question I have is obviously that there is no now contact with the old board, that the contacts are yourself, Stu, I'm assuming.
Yeah, I haven't
Yeah.
I haven't spoken to them well since the change. I do need to make you aware though, if it does proceed to witness evidence, which currently is due in August, but there's been an extension of 28 days agreed, so it won't be until September now. We're hoping for it not to get to witness evidence stage. We're hoping that it will be settled before that. However, if it does get to witness evidence stage, I will have to contact them because at the time of the incident, they were the directors. I will need their account as well. So I'll obviously be contacting yourselves in terms of the current evidence, but I will also need to contact them for the previous evidence as well.
No, that's absolutely fine. The evidence that we will, where do we stand for it in regards to, because obviously some of what we're aware of came about by the virtue of all the building being aware of this from a data leak, or a data hack, as they like to call it. We were not involved in that process. We don't know anything about who actioned that process. We were all just recipients of the information. But in that information, it does contain various issues relevant and various statements relevant to this case. So with the fact that we know that, where do we stand in terms of the old board if they're maintaining a defence position versus how we can maintain a defence position knowing what we know?
Quite realistically, we need to just focus on the incident itself. So in terms of the data leaks and whatnot, and I think there's several claims within the sort of pleadings about harassment, and I believe there was a data protection issue as well. We need to, well, I am simply instructed to act in relation to the escape of water itself on the date of the incident. So anything additional to that, I wouldn't even be able to comment on. Obviously, I'm aware of the data breach and whatnot, but I'm not instructed to act on that. So with regards to witness statements or witness evidence from yourselves, it would just be on a factual basis. I'm aware, obviously, at that time you weren't acting as directors. So it would literally just be a factual statement. You took over as directors on such and such a date. This is your current position or whatever it is. But we can cross that bridge when we come to it. Because as I say, we don't intend for it to get that far, because we are hopeful that this will settle in the next couple of months anyway.
Okay, well, that's good to know. Okay, yeah, I think that pretty much clears it up. As I say, that was really my major concern, is that we would end up in a position where we basically submit our views and what we know versus what the old board would most likely submit, and by default that would mean that the insurance would simply look at this and say, tatty buys, and then that leaves us all stuck. Or you know, beyond that, it means we're in a situation where we're either verifying something we do not believe to be correct, or knowingly committing
absolutely
perjury.
not.
So they were my issues.
Absolutely not. Yeah, no, because every statement is, of course, as you know, accompanied by a statement of truth. So we would never expect you to sign anything that you believe is not true. It's absolutely not what we would be, you know, expecting you to do. And obviously, as you rightly say, the consequences of that are contempt of court. So no, we would absolutely not expect you to do that or sign a statement that you don't believe is factually correct.
Okay, that's great. That pretty much, I think, for now, brings us more or less up to date and sort of clarifies where we're up to. I take it there's no related documentation or anything that needs to come our way at the present time?
No, absolutely nothing. The only thing that might come up, and it's not yet, but the claimant's made an application for specific disclosure. Basically, she's requesting various documents. I don't believe that the documents are relevant to the claim itself, because as I just said, we're only instructed to deal with the incident itself. You know, so for example, one of the things that has been requested is emails from the previous directors. We don't believe those emails are relevant because we don't know the nature of those emails, and I believe they're personal in nature. So if they are personal, then they simply wouldn't form part of the proceedings. So that being said, one of the things that she's requested is minutes of the meeting in previous director meetings that have taken place. Now, we have disclosed the minutes of the meetings that we've got. So I believe that that's not going to amount to anything in terms of the application. But it may be that if the judge says, well, actually, you do need to provide further disclosure of any minutes, I may need to come back to you and just request that. And I'm sure, obviously, as directors, you will have access to that, I imagine.
Well, I can answer that question for you right now. The previous board have not undertaken any activity at all to continue the legal duty to ensure the good continuation of the company. They have refused to provide us with any information, hand over any documentation or anything at all. So we are in possession of nothing from the previous board that hasn't been already circulated by the virtue of aforementioned data leaks. So yeah, we've had no official handover, no official documentation has been passed to us.
No problem. I mean, if anything, that's that works in our favour, because I've already disclosed everything I've got. So if you're saying you've not received anything further, or there's been no further minutes, then that's absolutely fine. We've got nothing further to disclose, so we will obviously.
I mean, obviously, as the new board, we have minutes which we're a little bit behind with actually typing up at the moment, but we do have minutes from all our meetings and so on, and recordings and transcripts from when we took over, but there's nothing from the time of the event available to us or from the old board. All as we have available from ourselves is obviously from the time of the takeover, which was the middle of May.
Okay, no, that's fine. As I say, depending on what the judge orders, I may or may not need the new minutes. But I'm not sure that it's entirely relevant, as I say, because I do believe that the previous minutes have already been circulated. So it really just depends on what the judge orders on the day.
Yeah.
Is that okay? Is there anything else that you need?
No, I think that covers all my questions.
Perfect. Julie, anything from you?
No, that's fine.
All right then, no problem. If you need me, obviously you've got my email address and you've got my number as well. So yeah, just feel free to drop me an email or give me a call.
Brilliant. That's great. Thank you. Thank you very much.
No problem.
Okay.
Take care, both.
Yes, take care.
Okay.
Thank you.
Bye-bye.
Thank you, Oscar. Thank you. Bye-bye. Bye-bye.
Bye.
Thank you. Bye.